heart is gleaming gold. They sail the waters, soar above the trees, to find the gem between the mountains and seas. Your children know we try though we may fall. We stand united now to heed your call. Our fathers fought the fights for liberty. Forever I'll defend Guyana free. Guyana, Guyana, I'll be holding on to you forevermore. Guyana, Guyana, may the blessings of God never leave your shore. Guyana, Guyana, I'll be holding on to you forevermore. Guyana, Guyana.
Look down from your window, no big city lights, just greenery. I don't know what you come for. Listen up, my dear, we're such a man free. Welcome to the land of many faces, not one, not two, but 6 different races. You know when the sun kisses your skin, you're in the right place. G-U-I-A-N-A, oh, that's my beautiful country. Come, let me take a walk with Brother Tiki. You'll see our landmarks and our monuments, they're so unique. The high brick structure, the lighthouse, the tallest wooden structure, cathedral, 176th Street, monuments, and the beautiful city hall. You know with the wind in your hair, you're in the right place. G-U-I-A-N-A, oh, that's my beautiful country. One people, one nation, one destiny. champion, let them watch you as you glow. No one can stop your vibes, all your powers are ignite. Let all the voices fade, now nothing will come in your way. 'Cause you are a ray of sunshine, everybody wants your sunlight. And you are a magic light bulb, everybody wants your brightness. Dark days will come and go, but you're still burning in the cold. You are your force to reckon with, when you eat, you feed your soul. No one can stop your shine, one more breath towards your goal. Breathe, free, breathe, you're a champion, let them see what's in your blood. 'Cause you are a ray of sunshine, everybody wants your sunlight. And you are a magic light bulb, everybody wants your brightness.
There are decisions. Each member of the court will deliver a decision, starting with Justice Rishi Prasad.
I'll be very brief. This notice of motion purports to invoke the Court of Appeal's original jurisdiction pursuant to Article 177(4) of Ghana's Constitution. On the face of it, an order seeking the interpretation of the words "more votes cast" in Article 177(2)(b) of the Constitution is prayed for. This is as a consequence of the Ghana Elections Commission's failure to determine a final credible count of votes cast at the general and regional elections of March 2nd, 2020, pursuant to Order Number 60 of 2020, as amended by Order dated the 29th of May, 2020. Several other consequential restraining orders are sought as follows, and I've stated it there, I won't go into it. A 35-paragraph affidavit supports this motion. The background and events leading up to this motion is well documented in the various submissions laid over, and this recital is thought unnecessary. Now, paragraph 14 of Order 69 of 2020 is amended by Order 29 is amended by Order of the 29th day of May 2020, is set out for purposes of context, and I wouldn't read the entire order, just the relevant aspect. Towards the end, it says, to make the declaration of the results of the final credible count of the elections held on the 2nd day of March 2020. Now, Article 177(4) of the Constitution, under the title "The President," states, the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president insofar as the question depends upon the qualification of any person for election or the interpretation of this Constitution, and any decision of the Court under this paragraph shall be final. The qualifications for elections as president is set out in Article 90. For what it's worth, the election to the National Assembly is set out in Article 53. Of critical and determinative importance, Article 177(5) provides, subject to the provisions of this Constitution, Parliament may make provision for giving effect to the provisions of this title without prejudice to the generality thereof. A, for the conduct of elections to the office of the President, and B, importantly, with respect to the persons by whom, the manner in which, and the conditions upon which proceedings for the determination of any questions such as is mentioned in the preceding paragraph may be instituted in the Court of Appeal. Now, a proper and lawful interpretation of Articles 177(4) and 177(5) leads, to my mind, to the inescapable conclusion that this court is without jurisdiction to entertain this motion for several reasons. There is no dispute that provisions have not been made by Parliament under Article 177(5)(b). The words "for giving effect to" is a clear indication that Parliament intended the provisions to be made in order to operationalize the Article 177(4) jurisdiction. Specific reference in Article 177(5)(b) to these critical provisions as it relates to whom, the manner in which, and the conditions upon which proceedings may be instituted in the Court of Appeal clearly intends it to be a necessary precondition. Provisions here are clearly required to complete the definition of the power or jurisdiction in question. See Chaitan and Peters against the Attorney General of Trinidad and Tobago, 2002. Crucial issues such as the locus standi and time limits are not provided for, which is fundamental to the completion of the court's jurisdiction. John Doe against the AG, relied upon by the applicant, is unhelpful in the context of the clear and specific wording of Article 177(5) and the well-established original and inherent jurisdiction of the High Court. John Doe's case does not avail the applicant. In the event that it was indeed Parliament's intention that Article 177(4) be operational without the necessary provisions required under Article 177(5), this motion still remains unsustainable. In this regard, reference is made to Re Luciquiana's application 1980-29 WIR at 130. Though it does not appear that the issue of provision making under Article 177(5) was raised, I find myself persuaded, if not bound, by the pronouncement of our apex court at the time as it relates to the scope and ambit of the jurisdiction conferred by virtue of 177(4). At page 140, R.H. Lapu, Justice of Appeal, said, and it's a lengthy quote, I'll just read the relevant part. Article 177 follows immediately under Title 4 of Part 2 of the Constitution, and it is headed, the President. The marginal note thereof being the election of President. The provisions deal with the machinery for election of a president under the Constitution. Paragraph 4 is concerned solely with the court's jurisdiction on a question as to the validity of election of a president under that machinery. Further, the court's jurisdiction is circumscribed. It is limited to questions as to the validity of an election of a president, insofar as the question depends A, upon the qualification of any person for election, or B, upon the interpretation of the Constitution. The qualification requirements are to be found in Article 90, and need not be settled as they are not pertinent to the matter at hand. I am unable to find anything in the wording of paragraph 4 construed in the context of the whole scheme of Title 4, Part 2 of the Constitution to warrant jurisdictional extension to a matter falling within the ambit of Section 10(1) of the Act. It is without a doubt, from a perusal of this motion, that the issue of the validity of the election of a president is not raised. The words or the interpretation of this Constitution is clearly circumscribed and applies only to the issue of the qualification of a person elected as a president. It does not lend itself to be interpreted as a roving commission. The High Court's original and inherent jurisdiction as it relates to the interpretation of our Constitution is well established for that purpose. For example, see Sections 18 of the High Court Act and Article 133 of our Constitution. There is yet another reason why this motion must fail. Article 177.4 speaks to the determination of any question as to the validity of the election of a president. A president is not yet elected pursuant to the machinery and the process contemplated by Article 177.2 and 6. This can hardly be the source of any serious contention. Whether one is deemed a president or referred to a president-elect is immaterial. It is clear that Article 177.4 contemplates an elected president. This is consistent with the general scheme of legislation in Guyana that governs the elections process, which only permits challenges after the elections process is completed. As a result, and additionally, this motion is simply premature. Now, Article 163(b)(1) vests in the High Court exclusive jurisdiction to determine any question, whether either generally or in particular place, an election has been lawfully conducted, or the result thereof has been or may have been affected by any unlawful act or omission. Provisions for the determination of the validity of an election is made by way of the National Assembly Validity of Elections Act, Chapter 104. See Petrie against the AG, Christopher Ram against the Attorney General, C. Kumar Singh, and Butler. The sanctity and exclusivity of the Elections Court is well established. See for Saunders, CCJP, President of the CCJ, in Christopher Ram. The National Assembly Validity of Elections Act provides for an exhaustive and exclusive procedure for any challenge to the validity of an election. The applicant here, in essence, contends that GCOM's order highlighted required a determination that the elections were credible and ultimately urges the court to pronounce. A consideration of the scope and effect of that order is, to my mind, intended here. Various pieces of evidence, quote unquote, was provided to GCOM and attached to the affidavit in support of motion here. Those allegations and unsolicited opinions, according to the applicant, establishes that the election was not credible. Unlawful acts and omissions underscores the applicant's complaint here. I have perused the various pieces of legislation that governs the elections process and the powers of GCOM. I am unable to find any provision which even suggests that GCOM is empowered to embark on what would be an evidential-based credibility exercise, and by extension, and now an election process. That jurisdiction falls exclusively within the realms of an election court and the chair of GCOM, so properly determined. It is noted from a perusal of the authorities emanating from India that there is specific authority in the Elections Commission in that jurisdiction to annul and have fresh polls at an affected polling station. This is a stark difference in context. The issues raised here, to my mind, is not concerned with the interpretation of the Constitution. Those issues fall squarely within the exclusive jurisdiction of the High Court, under and by virtue of Article 163(b)(1). The unlawfulness or otherwise of an act or omission is clearly a matter for the Elections Court. In closing, it should be noted that I have deliberately refrained from dealing with, in any particular detail, those core and peripheral issues which have arisen here that may be the subject matter for consideration by an elections court. This is, of course, in an effort to avoid what may amount to pronouncements or opinions prejudicial to the elections court's consideration of those issues properly before it. In the circumstances and for the brief reasons given, I find that this notice of motion is wholly misconceived and is accordingly struck out for want of jurisdiction.
The decision which I render now is essentially an oral one, for which I've made notes and for which I undertake to write up in full and to make available to the registrar of the court in another few hours. The facts which give rise to this notice of motion may be briefly stated as follows. Regional and general elections were held in Guyana on the 2nd of March 2020. Subsequent thereto, objections were raised pertaining to the declarations made on March 5th and March 13th, respectively, by the returning officer for Region 4, or District 4, in an attempt to quell discord among the political parties and to ensure transparency in the election process. The third respondent agreed to conduct a recount of the ballots in all 10 electoral districts. To facilitate the recount process, Order Number 60 of 2020, dated 4th May 2020, was issued by the third respondent and published in the Official Gazette Extraordinary Edition to regulate the recount, which was to take place from 6th May 2020. An amendment to this order was issued and published in the Official Gazette on 29th of May 2020. During the recount process, objections were made in respect of ballot boxes by elections agents, whereby discrepancies and anomalies were pointed out, which were recorded in an observation report. On 13 June, the first respondent submitted this report in accordance with paragraph 12 of the order and stated that the summation of anomalies and instances of voter impersonation identified in districts 1 to 10 clearly do not appear to satisfy the criteria of impartiality, fairness, and compliance with provisions of the Constitution and the Representation of the People Act. Consequently, on the basis of the votes counted and upon information furnished from the recount, it cannot be ascertained that the results for the 10 districts meet the standard of fair and credible elections. On June 16th, the third respondent stated it did not have legal authority to determine the credibility of the March 2nd general and regional elections, and by extension, to arrive at a final credible count as required by the aforesaid order, on the basis that such questions must be determined exclusively by the High Court under Article 163, 1B of the Constitution, via an election petition. Therefore, thereafter, the second respondent directed the first respondent in writing to submit his report pursuant to Section 96 of the Representation of the People's Act and Article 177(2)(b) of the Constitution, using the results of the recount for consideration by the Commission. Dissatisfied with the foregoing events, the applicant filed his instant motion seeking the release outlined earlier by my brother. The applicant contends that the main objective of the recount process was to determine a final credible count before a declaration of the election results can be made. The applicant further contends that the order established the criteria for determining the final credible count and that the first respondent is required to determine the total number of valid votes before a report under Section 96 of the RPA can be prepared. Contends as well that GCOM failed to determine a final credible count and or credibility of the result of the elections as provided for in the order. It is further claimed that despite these failures, the second respondent directed the first respondent to submit his report using the results of the national recount. In the interest of time and owing to the public interest, this court acceded to the request to join the additional respondents being representative of political parties likely to be affected by the outcome of these proceedings. I reduce the issues in this matter to be two. Firstly, whether this court has jurisdiction to entertain this notice of motion, and secondly, whether Order 60 of 2020 required GCOM to determine the final credible count of these elections. I move to my analysis. In its effort to resolve the difficulty which it considered had arisen in the aftermath of the March 2nd elections, GCOM had recourse to Article 162, 1B of the Constitution and Section 22 of the Elections Laws Amendment Act, and in so doing, provided a snapshot of the difficulties which the Commission considered confronting it at the time in the recitals of the order bringing the recount into being. These provided as follows: whereas the declarations of the results pursuant to Section 84, 1 of the Representation of the People Act, Chapter 103, have been made, but requests for recounts in a number of electoral districts have been rejected, aborted, or held in abeyance, and the report pursuant to Section 96(2) of the Representation of the People Act had been delivered to the chairman of the Commission and held in abeyance, and aspects of the election process have been subjected to legal proceedings. And whereas the President and leader of the opposition and all contesting parties have agreed to a CARICOM proposal for a total recount of all districts, and as a means of assuaging the contesting parties and determining a final credible count. And so it is out of this necessity, out of this scenario, that this new election regime was birthed. Turns out, however, that this special regime created by Order 60 of 2020, that this special regime created through this legal detour, it turns out to be hybrid in nature, incorporating as it did features of both the old and the regime created by the order. Order 60 of 2020 vests GCOM with powers and responsibilities, the remedies for which actions and omissions on the part of Commission officials are in some respects akin to those of the High Court, and in others, the ordinary jurisdiction, and in others akin to that of an election court. As a necessary consequence thereof, GCOM's actions and omissions pursuant to Order 60 of 2020 are impacted by the constitutional and statutory provisions of both the original and the new electoral regime. It is in this context, or in the context of this newly created propinquity, that the applicant has approached the court for an interpretation of words used in one of those constitutional provisions which directly impacted the directions given by the chairman to the chief elections officer in her letter of June 16th. Through our notice of motion, the applicant, Eslyn David, seeks to invoke this court's jurisdiction to interpret words which impacted provisions words in the impacted provisions insofar as they now affect the validity of the election of the president. The question of this court's jurisdiction is, in my respectful opinion, the foremost issue in this application. And the question, therefore, of jurisdiction. I note that Article 177(4) of the Constitution reads, the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, insofar as that question depends upon the qualification of any person for election or the interpretation of this Constitution. And any decision of that court under this paragraph shall be final. This provision, I'm to say, is peculiar to Guyana, to the Guyana Constitution, and is not to be found anywhere else in the Constitution of the Commonwealth region. The respondents contend for diverse reasons that the narrow, exclusive jurisdiction created by Article 177(4) cannot be invoked in the circumstances of David's case. The first consideration is whether the action falls within the ambit of this said provision. What is meant by the words used in Article 177(4)? The case, UC Guyana, the application, UC Guyana, the 1980 application, an application at the time Guyana received its 1980 constitution, tends to shed some light on the intendment of 177(4), which article was invoked in these proceedings. The Court of Appeal at that time held that the paragraph conferred a very limited jurisdiction. Laku, Justice of Appeal, in examining the wording of paragraph 4 in order to ascertain the extent of the court's jurisdiction, observed, the provisions deal with the machinery for election of a president under the Constitution. Paragraph 4 is concerned solely with the court's jurisdiction on a question as to the validity of election of a president under that machinery. Further, the court's jurisdiction is circumscribed. It is limited to questions as to the validity of an election of a president insofar as such questions depend A, upon the qualification of any person for election, or B, upon the interpretation of the Constitution, suggesting thereby, in my respectful view, without more, that the limbs for testing the validity of the election of a president were really to be read disjunctively. The question of jurisdiction has been extensively argued by the parties in this matter. Mr. Jonas, for one of the added respondents, submitted that this court has no jurisdiction over this matter under 177(4) in the absence of an elected president. He said the article requires the president to be elected before the jurisdiction which it confers can be invoked, as the words as to the validity of an election of president in 177(4) could only mean that in order to invoke the article, the president must have already been elected. This position, this court believes, is not borne out by 177(6), which clearly, from its reference to the documents referred therein, contemplates equally a situation as in the instant case where the election process has not yet been concluded. It was further submitted that Article 177(4) confers jurisdiction to question the qualification of the person elected as president. And since none of these issues related to the qualification of the president, assuming that he has already been appointed, has been raised in this motion, the court would therefore have no jurisdiction over this matter. This contention being that the affidavit discloses no facts or evidence that brings this matter within the ambit of 177(4). That is to say, that an election of a president has taken place to finality and that the qualification of the president is challenged. The words or the interpretation of this constitution must be construed as limited to the issue of the qualification of a person elected as president. Reliance being placed again on the very UC Guyana application matter which I earlier referred to. It is further submitted that it's the High Court that has jurisdiction over constitutional matters as part of its wider original jurisdiction under Section 18 of the High Court Act and Article 133 of the Constitution, and that the history of constitutional law in Guyana confirms that it is the High Court that has jurisdiction over questions relating to the interpretation of the Constitution, while the Court of Appeal has an appellate jurisdiction. Therefore, where the Court of Appeal has been given an original jurisdiction, that original jurisdiction cannot be won at large so as to clash with and cause confusion in the administration of justice. Counsel for the second named respondent submitted that Article 177.4 grants this court a narrow, special exclusive jurisdiction to hear and determine any question as to the validity of the election of a president, insofar as that question turns upon the qualification of any person for election or the interpretation of this Constitution, and that the words or the interpretation of the Constitution in Article 177.4 speak to the interpretation of constitutional provisions in relation to the qualification of any person for election to the office of the president, office of president. Since the order sought at paragraph A of the notice of motion amounts effectively to the interpretation of Order 60 of 2020 and not the Constitution, this court had no jurisdiction. Similarly, Mr. Jonas submitted that this court is not vested with original jurisdiction to hear questions as to the interpretation of the Constitution outside of its very narrow special jurisdiction. Contends that Article 133 instead vests the Court of Appeal to hear appeals from the High Court on questions of constitutional interpretation, and submits further that since the first two orders in the motion do not touch and concern the qualification of a person elected president, the application is misconceived and ought to be struck out without more. Further, he contends that on plain reading of 177, this article contemplates a person already declared by GCOM as president, and since none has been so declared, the narrow jurisdiction of Article 177 cannot yet be invoked. It was further submitted that the relief sought cannot be determined by this court, but instead must be pursued by an election petition pursuant to Article 163(1)(b) of the Constitution, which confers on the High Court the exclusive jurisdiction to determine questions related to the validity of an election. Since Article 163(1)(b) stipulates that the High Court shall have exclusive jurisdiction, GCOM cannot clothe itself with jurisdiction to establish itself as a court of law to determine credibility of an election. Further, the Commission cannot arrogate unto itself a jurisdiction to determine the credibility of an election or any unlawful act, since no specific power was conferred upon it by Article 162(1)(b) to so do. The view was further posited, and that since Parliament gave the exclusive jurisdiction to the High Court to determine lawfulness and validity of an election, the recount order cannot be interpreted to have taken away the exclusive jurisdiction granted to the High Court and placed into the arms of GCOM. Reference being made to Article 8 of the Constitution and the inconsistency of legislation with the supreme law. It was further submitted that once the Commission issues a decision, it cannot be impugned except by an election petition, and that further resolution of election disputes must be by the judicial process only. Several authorities were cited from Indira Gandhi and Raj Narayan, and others. These irregularities, and the contention being thus that irregularities during the progress of the election process, even if they vitiated the election, should be brought before the High Court by an election petition and not be subject of disputes before any court while the election process is underway, culminating in declaration of results, citing Ponnaswamy and the returning officer of another Indian authority. It was further submitted that such a challenge cannot be entertained at this time on the basis that it is premature. Any challenge to the validity of an election and any dispute or claim of any irregularities or illegalities in relation to an election can only form the basis of an election petition after the result of the election has been made. Citing here again Mohinder Singh and Manda Jagannath and Ratnam. Therefore, in accordance with the statutory requirements, and in order not to allow election proceedings to be unduly retarded or protracted, any challenge to the validity of an election and any dispute or claim of any irregularities or illegalities in relation to an election must be brought, it was contended by the added respondents, by way of an election petition after the result of the election had been made known. The Attorney General, Mr. Basil Williams, agreeing with the applicant, however, submitted that Article 177.4 should be read disjunctively, as on the one hand, it deals with qualifications of the President, and on the other, it pertains to the interpretation of the Constitution, suggesting that the limbs must be read disjunctively, where they relate to the questions involving the validity of the elections of the President. The Attorney General is therefore of the view that this court has jurisdiction to deal with the issues of interpretation raised by the fourth named respondent. And he also cited several Indian authorities, extending his observations, however, contending that the Commission had the authority even to annul the elections. Mr. Mendes, for the fifth and sixth respondents, submitted that this court does not possess jurisdiction over this matter for several reasons. Firstly, that Parliament's failure to make provision for the exercise of the court's jurisdiction pursuant to Article 177(5)(b) deprives the court jurisdiction under Article 177(4). He placed reliance on Chaitan and Peters and the Attorney General, Trinidad and Tobago Authority, in which it was held that, as a general rule, the failure to prescribe what is to be prescribed does deprive a court of jurisdiction. Mr. Mendes further submitted that upon a proper construction of Article 177(2), 4, and 6, the jurisdiction of this court under Article 177(4) can only be invoked after a president has been elected. Article 177(4), he contends, relates to any question as to the validity of an election of a president. And since there has been no declaration of the election of a president, the court's jurisdiction cannot be invoked because there is simply no basis for any determination under Article 177(4). He also contended that the reliefs sought in the notice of motion fall outside of the ambit of Article 177(4), which he contends is restricted to questions as to the validity of an election of a president, which depends upon the qualification of any person for election or the interpretation of the Constitution. He also referred to UC Guyana, where he observed, Laku Justice of Appeal noted that the Constitution has, in addition, invested the Court of Appeal with exclusive jurisdiction under the provisions of Article 177(4) to hear and determine certain questions. He, however, contends that that exclusive jurisdiction is defined within the ambit of paragraph 4 of the article, which must be examined, and that is in order to ascertain the extent of the court's jurisdiction. In the consequences where the notice of motion does not raise any of these issues, it was his contention that the court had no jurisdiction to grant the relief sought. Mr. Mendes further submitted that Article 177.4 does not permit interpretation at large, as he termed it. It only permitted constitutional interpretation within a specific context, and that is as to the validity of an election of a president. And since the reliefs sought do not ask for any interpretation of the Constitution at all, but as he contends, requires the court to interpret the GCOM's order and the amended order, this court had no jurisdiction under 177.4. Mr. Mendes further contended that the relief sought are more properly reserved for an election petition pursuant to Article 163(1)(b) and Section 3 of Chapter 104, and that the determination of these issues by this court would amount to an encroachment of the High Court's jurisdiction under the said Article 163. Conversely, however, counsel for the applicant held the view that Parliament's failure to make rules for the determination of questions as to the validity of an election of a president pursuant to Article 177.5 of the Constitution does not strip this court of its exclusive jurisdiction under the said article. Reliance was placed on John Doe and the Attorney General of Guyana, where the Privy Council stated that, and I quote, "So long as nothing has been done by Parliament or by the rulemaking authority under the Supreme Court of Judicature Ordinance to regulate the practice or procedure upon such applications, the right to apply to the High Court under paragraph 1 remains in the Lordship's view unqualified." And so the applicant is contending that anyone, any elector in the circumstances, could approach the Court of Appeal for relief in the appropriate circumstances, and that the fact that these rules have not been promulgated did not diminish the jurisdiction of the Court of Appeal in that regard. The counsel for the applicant also contended that in the absence of a procedure provided by Parliament, the ordinary procedures can be invoked to approach the court under 177.4, placing reliance again on John Doe, where, and I quote, "use by an applicant of any form of procedure by which the High Court, the Court of Appeal in this instance, can be approached to invoke the exercise of any of its powers. They are not confined to the procedure appropriate to an ordinary civil action, although they would include that procedure until other provision was made." Further, counsel for the applicant contended the use of the word "may" in Article 177.5, where it states that Parliament may make provision for giving effect to, indicates that Parliament's provision was not a precondition to the exercise of the court's jurisdiction under 177.4. And counsel contended if it was, the use of the word "shall" would have been expressed. Reliance was placed there on the case of Withers and Withers, where the words under the Matrimonial Causes Ordinance number 34 of 1960 expressed that the jurisdiction of the court was, and I quote, "subject to any rules which may be made," unquote. Chief Justice Crane at the time stated, provided that where no rules were made, it was the intent of Parliament that ordinary rules in place at the time were to be used to approach the court. It was further submitted by counsel for the applicant that the jurisdiction granted to this court under 177.4 to interpret the Constitution in relation to an election petition is separate and distinct from the jurisdiction granted to the High Court under Article 163 to determine any question regarding the qualification of election of a person to the National Assembly. That consequently, the election petition process as provided for under Article 163 and the National Assembly Validity of Election Act relates to the election of a person to the National Assembly. It, however, does not replace the Court of Appeal's exclusive jurisdiction as it relates to the election of a person to the office of the president. Furthermore, the completion of the electoral process by a declaration of results is not a necessary precondition to invoke the jurisdiction of the Court of Appeal under Article 177.4. That any person may at any stage during the electoral process approach the Court of Appeal pursuant to Article 177.4, seeking the interpretation of any provision of the Constitution so far as such an interpretation impacted or touched and concerned the election of a president. In my respectful assessment of these submissions, the Constitution of Guyana established separate elections for members of the National Assembly and for the president, even though those elections are taken together. Article 62 states that subject to Article 162, the members of the National Assembly are to be elected in accordance with the system of proportional representation pursuant to Article 161. Article 91 provides, importantly, that the president shall be elected by the people in the manner prescribed in Article 177. And so Article 91 takes you to the very Article 177, which is under consideration by this court. Article 177 states that any list of candidates for an election held pursuant to Article 60 shall designate not more than one of those candidates as a presidential candidate, and that an elector voting at such an election is deemed to be voting in favor of the presidential candidate named in the list. And so there are two elections subsisting at one and the same time. Article 163, as its marginal note suggests, it confers on the High Court an exclusive jurisdiction to determine questions as to the membership and elections. A review of that said article, Article 163, states it relates to 1, qualification of any person to be elected as a member of the National Assembly; 2, whether an election has been lawfully conducted or the result thereof has been affected by any unlawful act or omission; 3, whether the allocation of seats in the National Assembly have been properly done; 4, whether a member of the National Assembly is required to cease to exercise any of his or her functions as a member thereof; the filling of a seat, whether a speaker was lawfully elected; and an appeal from the decision of the High Court, which lies in these matters to the Court of Appeal by Article 163(3). To give effect to the exclusive jurisdiction of the High Court, the National Assembly Validity of Elections Law was passed. And the long title for this act states that it is an act to provide for the determination of questions relating to the validity of elections and other matters affecting elections to the National Assembly and the allocations of seats in the National Assembly. By Section 98 of the Representation of the People Act, the representative of the list extracts from the list as many names belonging to candidates selected by him, and the chief election officer shall declare such name to be elected to the National Assembly. Article 51 of the Constitution states that Parliament shall consist of the President and the National Assembly. And Article 52 states that the National Assembly shall consist of such members elected in accordance with the provisions of the Constitution and in accordance with any laws made by Parliament in that behalf. And so that the President is not a member of the National Assembly. And so that distinction is being made consistently in the constitutional architecture. The President is being treated separately in Title 4, the National Assembly in Title 2, in that part which deals with rules. And so it is clear from my review that there is no provision in Article 163 of the National Assembly Validity of Elections Act which is applicable to the President. Further, in my review, I noted that Article 232 defines election to mean election of members to serve in the National Assembly or the elected body established by or under the Constitution. Election, I noted, is not defined in the National Assembly Validity of Elections Act, and it must therefore have the meaning given to it by the Constitution. On the issue of appeals, which comes for the fourth and fifth respondents referred to at some length, Article 133 provides for appeals on the constitutional questions and fundamental rights to the Court of Appeal. It is important to note, however, that Article 133.2 states that the conferral of jurisdiction in respect of appeals on constitutional and fundamental rights does not apply to matters provided for in Article 163. Article 163.3 conferred appellate jurisdiction on the Court of Appeal in respect of specified electoral matters set out in Article 163.1. And so the question of competing and concurrent jurisdictions does not arise in that regard. As I pointed out before in my respectful review, nothing in Article 163.1 is applicable to the election of a president. And so I have formed the opinion, respectfully so, that Article 177.4 establishes a separate exclusive jurisdiction in the Court of Appeal. And that is to say, in respect of appeals to hear and determine questions as to the validity of an election of a president, insofar as that question depends on, firstly, the qualification of any person or the interpretation of the Constitution. Respectfully, therefore, it is my view that the High Court in Article 163 or the National Assembly Validity of Elections Law does not have this jurisdiction. This is an original jurisdiction in the Constitution. And so the question of concurrent and competing jurisdictions as suggested by counsel for respondents 5 and 6 does not arise. It is my respectful view further that Article 177.4 thus confers jurisdiction on this court in respect of the validity of an election where such election depends either on the qualification of any person for election or upon the interpretation of this Constitution. And it is therefore not possible to institute any proceeding in this regard in the High Court in its original jurisdiction, nor in its constitutional jurisdiction, as conferred by Article 153 or Article 163. As the jurisdiction of the Court of Appeal in matters set out in Article 163.1 emanates from Article 163.3 and not Article 177.4. I therefore form the respectful view that Article 177.4 is a separate jurisdiction, carefully carved out and distinct from the High Court jurisdiction and from other appellate jurisdictions of the Court of Appeal under the Constitution. In my respectful view, the issue of the court, the issue before the court, is one as to the validity of a president, which in the instant circumstances depends on the interpretation of the Constitution, namely Article 177.2, and that Article 177.4 affords jurisdiction in that regard in order to ascertain the true meaning of the words more votes cast in Article 177.2, necessary in this regard, in this instant case, for the valid election of a president. There is no provision, in my respectful view, in law in respect of which this issue can be raised in any other court than the Court of Appeal. I have found and ruled accordingly that this issue therefore falls squarely within the jurisdiction of Article 177.4 of the Constitution. Insofar as the second issue is concerned, I will return very briefly to submissions by the second named respondent as they become pivotal to my finding in that regard. Counsel for the second named respondent contends that the applicant's affidavit suggests that the application is really an attempt to interpret the recount order rather than the Constitution itself in Article 1, as Article 177.4 requires. She contends further that by its very construct, Article 177.4 refers to circumstances where the president has already been elected, and in that sense, the application is premature. She also sought to distinguish the cases relied upon by the applicant, contending principally that the constitution and legislative framework in which they are set is distinguishable from ours, as the Indian elections are based on the first past the post system using constituencies, whereas ours is based on proportional representation, where the electors vote for one list. Rebutting this observation, however, in his rejoinder, Mr. Jeremy for the applicant observed applicable to the holders of high constitutional office and referenced the holders of such office at GCOM, including the chairman and the chief elections officer. Counsel for the second name concluded by contending that the Constitution is the supreme law, and therefore to ask GCOM through the recount order to take over the jurisdiction from the High Court under 163 and to place it in the arms of GCOM is impossible, contending effectively that GCOM could not do what it undertook to do in the recount order in the first place. It is this admission, coupled with the directions given to the CEO in the June 16th letter, which bolsters my view that the need to interpret the words used in Article 177.2 arises in these circumstances. Counsel for the second name respondent admitted that GCOM did set as its objective determining the final credible count of votes, but by saying that it would be effectively a usurpation of the High Court's function after the fact of its inclusion in the very order which brought the recount into being, concedes an abdication of sorts of the Commission's responsibilities in that regard. Beyond that, I concluded, upon my examination of the affidavits and the exhibits exhibited thereto, that the words determining a final credible count inserted into Order 60 of 2020 were not mere surplusage, considering that they are twice deployed. Firstly, in the third recital, at the beginning of the original order, and then included in the final paragraph of the amended order. I also considered the fact that paragraph 16 of the said order expressly incorporates the recitals into the order. And I conclude that the reasonable inference to be drawn from the inclusion of this formulation of words is that the Commission, having defined it as an objective of the recount, must have intended that those words be given effect to. Accordingly, I find that GCOM did have or does have a responsibility to determine the final credible count of the results. It would be reasonable to presume that that final credible count would require both a quantitative and qualitative assessment of reports and the summary of observations submitted to the Commission in compliance with Order 60 of 2020. The reference by the chairman to Article 177.2 and Section 96 of the Representation of the People Act in our letter to the Chief Elections Officer, directing that he prepares a report for submission to the Commission using the results of the recount, bring into sharp focus the words used in that provision, that is to say 177.2, having regard to their implications when juxtaposed with the words valid votes used in the other legislative provision, Section 96 of the Representation of the People's Act, and when measured contextually against the backdrop of the stated objective of the recount, that is to say, to determine a final federal count. This circumstance, in my respectful view, impacts directly the validity of the election of the president, and for the reasons I already adduced, grounds jurisdiction in this court under Article 177.4, and I so find. Insofar as the orders are concerned, I do agree with the added respondents that owing to the nature of these proceedings and the very narrow special jurisdiction created by Article 177.4, that such jurisdiction does not extend to the granting of the injunctive relief prayed for by the applicant. And so, by way of order, I say it is hereby ordered that the words "more votes cast" in Article 177.2b of the Constitution of the Cooperative Republic of Guyana be interpreted to mean more valid votes cast within the meaning of Order 60 of 2020. I thank you.
Eslin David has approached the Court of Appeal for several orders. The orders include a declaration that the Guyana Elections Commission, GECOM, has failed to act in accordance with the terms of Order 60 of 2020, and its addendum dated the 29th of May, in that GECOM has failed to determine a final credible count and/or the credibility of the results of the general and regional elections held on the 2nd of March 2020, as required by Order 60 of 2020. B, she claims an order that there be an interpretation of the words "more votes are cast" in Article 177.2b of the Constitution of Guyana. Orders are also sought to restrain the Chief Elections Officer, the CEO, from complying with certain directions given to him by the chairperson of GECOM on the 16th of June 2020. By letter from the chairperson, the CEO was directed to prepare a report for submission to GECOM pursuant to Article 177.2b of the Constitution of Guyana and Section 96 of the Representation of the People Act, Chapter 103, using the results of the recount for consideration by the Commission. A number of injunctions. The injunctions, in essence, are against the CEO presenting a report which does not reflect votes which are valid within the meaning of Order 60 of 2020. And that order was issued by the Commission and contained several recitals, which were all deemed to be part of the order. The applicant seeks to move the Court of Appeal pursuant to the jurisdiction conferred on this court by Article 177(4) of the Constitution. That article states that the Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, insofar as that question depends upon the qualification of any person for election or the interpretation of this Constitution. And any decision of this court under this paragraph shall be final. Article 177, under which paragraph 4 falls, is titled Election of the President, and Article 177(2)(b), which is very relevant in these proceedings, provides in short that if there are 2 or more presidential candidates and more votes are cast in favor of any list of candidates, the presidential candidate designated in that list shall be deemed by the chairperson to be elected president. The paragraph further states that the president shall be so declared by the chairperson acting only in accordance with the advice of the CEO, after such advice has been tendered to the commission at a duly summoned meeting. It was under this provision that the chairperson acted when she wrote to the CEO on the 16th of June and requested him to prepare his report. Section 96 of the RPA provides for the ascertainment of valid votes and the allocation of seats under sections 97 and 98, that's seats in the National Assembly. The chairperson's letter and the CEO's report would lead to the declaration of the results of the national and regional elections held on the 2nd of March 2020 and would be the end of the election process. The applicant's contention is that the word more votes cast in Article 177(2)(b) should be interpreted to mean more valid votes in keeping with the terms of Order 60. According to her, the terms of the order necessitate such an interpretation. This case raises 2 important issues. The first, whether the Court of Appeal has the jurisdiction under Article 177(4) of the Constitution, and 2, the scope and status of Order 60 and its addendum dated the 29th of May 2020 in the machinery contained in Article 177(2)(b). Well, my colleagues have gone through the various submissions of counsel, and I have noted them. Maybe in fairness to counsel, I should outline some of what they said. But Mr. Jeremy, for the applicant, said that once there is an issue regarding the election of a president, insofar as it relates to qualification of any person for election to that post, or matters relating to the interpretation of the Constitution, Article 177(4) can be invoked. In this regard, Article 177(5) provides that Parliament may make provision for giving effect to the provisions of Article 177 and may make provision A for the conduct of elections to the office of President, and B with respect to the persons by whom, the manner in which, and the conditions upon which proceedings for the determination of any question
such as is mentioned in paragraph 4, may be instituted in the Court of Appeal. And it goes on to state that provision may be made for those matters by rules of court. Ms. Counsel cited a passage from John Doe against the Attorney General, which was quoted by my colleagues in their speeches, and so I won't repeat, but he asked the court to apply that reasoning, in this case, to the operation of Article 177.4, and to find that to the extent that no rules have been enacted, the access of the applicant remains unqualified. And therefore, the applicant is not barred from seeking relief. And in the absence of any other provision made by Parliament, this applicant, in this case, should not be barred from seeking redress under Article 177.4. In her application, the applicant has asked the Court of Appeal to interpret Article 177.2b with emphasis on the term "if more votes are cast." She argues that generally Article 177.2b empowers the Chief Elections Officer to advise the Chairman of the Elections Commission on the presidential candidate who would be deemed elected after obtaining more votes cast in favor of his or her list. The applicant's attorney contends that prior to the recount order number 60 of 2020, Section 96 of the Representation of the People Act was the basis of determination of the results of the election. And according to him, the recount order brought with it a new and different legal regime. It introduced a new standard and required the president's election to be based on a declaration of the credibility of elections. And for this reason, the applicant urged this court that the words "if more votes are cast" against must be read against the backdrop of the recount order and should be interpreted accordingly. Thus, an interpretation of those terms found in the Constitution is being sought. The first named respondent, Chief Elections Officer, was not represented, nor did he appear in these proceedings. The second named respondent, Ms. Kite, on behalf of the chair of the Elections Commission, made reference to the principle of nocetur associis, which means words derive color from those which surround them. And the cases that support that principle are Bourne and Norrie and Primator and Inland Revenue Commissioners against Frere. So this rule is commonly referred to as the context rule, in that it states that the words derive their color from the words which surround them. Applying this rule, a general word must take its meaning from the surrounding words with which it is used, and the word or words must be interpreted in light of the context being used. Ms. Kite Thomas submitted that while various aids to construction may be utilized, any construction adopted must contemplate the context being used. Counsel argued that Article 177.4 gave the Court of Appeal a narrow, special, exclusive jurisdiction to hear and determine any issues that arise in relation to the validity of an election of a president, to the extent that that question turns upon the qualification of any person for election or interpretation of the Constitution. But she drew the court's attention to the fact that the marginal note refers to election of a president. Thus, it can be gleaned, according to her, that the impugned article deals with interpretation of words in a constitutional provision that touch and concern the president's qualifications, and anything outside of that parameter falls within the ambit of the High Court. Ms. Knight further submitted that Article 133(1) instead vested the Court of Appeal to hear appeals from the High Court on questions of constitutional interpretation. As such, the first two orders seeking a declaration that GCOM act in accordance with its Order 60 of 2020 and to interpret the words as it seeks, that order does not fall within the jurisdiction of the Court of Appeal, and that the application should be dismissed. I can briefly mention the Attorney General's submissions. Those submissions were aligned with the applicants to a limited extent. They were much more extreme in what they asked the court to find. But for the most part, he asked the court to find that it had jurisdiction under Article 177(4), contending that just like the applicant, this matter ought, the relief as regards the jurisdiction of the court ought to be granted in relation to interpretation of the Constitution. And he asked that an interpretation be placed which enabled the court to interpret the words in 177(2)(b) as was sought by the applicant. Mr. Mendez, senior counsel, made wide-ranging submissions. He, in similar vein, contended that the Court of Appeal does not have jurisdiction to hear this matter, and he submitted that Article 177(4) is not yet right to be invoked, since there is only one sitting president at the moment. He said the declaration has not yet been made, and the applicant must therefore await the declaration of the president before invoking Article 177(4). Mr. Mendez submitted further that the issues that the applicant wishes to ventilate are matters for the exclusive jurisdiction of an election petition, which is provided for under Article 163 of the Constitution, and which essentially is a jurisdiction exercised by the High Court. Senior counsel argued that the applicant's case for invalidation calls for an interpretation of the Constitution. However, what would be called into interpretation would be the duties and responsibilities of GCOM under the recount order, and a determination that GCOM had breached the order, and he urged the court not to venture into such a determination. And finally, he argued that where the Court of Appeal has been given an original jurisdiction, that original jurisdiction should not contradict or cause confusion in the administration of justice. and that the court should stay instead within the limits of Article 177(4). He also gave us another reason, the fact that no rules had been promulgated or enacted under Article 177(5) to give effect to the access to the court under Article 177(4). Thus, he felt that there was no basis on which that jurisdiction could be activated. And as Mr. Ramkaran also argued along similar lines, Mr. Kashir Khan suggested that even if the court had the jurisdiction, there was nothing to justify the exercise of that jurisdiction in so far as the reliefs which are sought are concerned. So I move now to my analysis. It is clear from Eslyn David's application and her assertions in the supporting affidavit that the real issues raised in this application, the real issue raised in this application is the scope and effect of the order and addendum in relation to Article 177(2)(b). And also importantly, whether the second limb of Article 177(4), that is the power to interpret the Constitution in relation to the election of a president, is indeed conferred on this court as contended by the applicant. The applicant complains that the chairperson's decision of the 16th of June and the contents of her letter to the CEO were not in keeping with the terms of Order 60 of 2020. And it is noted that in the decision of the 16th of June, which was exhibited to the applicant's affidavit, that's the decision of the commission, as expressed by the chairperson stated that a number of anomalies were contained in the summaries of the CEO's observation report, which had been submitted to the commission, and expressed the view that the commission conclusively determined the matters as the commission did not have the power of a court of law. The chairperson further stated that some of the allegations were of a serious nature and must be addressed by a court and not by the commission. After stating why the issues fell within the jurisdiction of the High Court, the chairperson concluded, I quote, "In light of the foregoing, and in keeping with Order 60 of 2020 and its addendum, I hereby request the CEO to prepare and submit to the Commission a report to ascertain the result of the election under Section 96. I wouldn't go into UC Quayana's case, which discussed the jurisdiction of the High Court, and in relation to Article 177(4). But I think that the crucial issue in relation to Article 177(4) is whether or, the word or is disjunctive or conjunctive. The interpretation that is referred to in Article 177(4), is it limited to an interpretation matters relating to the qualification of the president, or is it a separate jurisdiction? As the court said in UC Guyana, the court's jurisdiction is circumscribed. It is limited to questions as to the validity of the election of a president, insofar as such questions depend, A, upon the qualification of any person for election, or B, upon the interpretation of the Constitution. The qualification requirements are to be found in Article 90 and need not be set out as they were not pertinent. But in that case, the court did exercise its jurisdiction to interpret Article 177.4 in the context of that case, and it had to determine whether the rules regarding the president also applied to a transitional president. And so that case was illustrated that the interpretation could be a little wider than the qualification itself. Going back to the provisions in Article 177.4, the question is whether the court's power to interpret is limited to the qualification of the president, or whether its powers to interpret can extend to the election of a president, so as to place a special interpretation on the words "if more votes are cast" in Article 177.2b. I consider that this jurisdiction does not collide with the jurisdiction of the High Court under Article 133 and with the jurisdiction of the Court of Appeal under the same article. It seems to me, however, that Order 60 of 2020 had sufficient force to impact the interpretation of those words in Article 177.2b in relation to the elections of the 2nd of March 2020. To my mind, the court is well within its jurisdiction as accorded to it within the confines of Article 177.4, which creates two limbs for jurisdiction. And that jurisdiction turns on the election of a president. Whether the court is exercising the jurisdiction in relation to qualification, or whether the court is exercising its jurisdiction in relation to interpretation, the jurisdiction turns on the election of a president when one considers the wording of Article 177.4. And so I hold that the words "if more votes are cast" are subject to the terms of Order 60 of 2020, because I believe that I'm allowed to interpret, the court is allowed to interpret 177.2b as part of that jurisdiction which is conferred under Article 177.4. To my mind, the fact that no rules have been enacted in relation to giving access or giving effect to this Article 177.4 does not bar the exercise of the court's jurisdiction in giving effect to the terms of the order, and in making this order and in granting the relief at this stage of the process. I do not agree that if uh, or is read disjunctively, that this would lead to an absurd result, since it only extends, the interpretation only extends to a provision within the terms of Article 177. So I do not accept that this court would be venturing out of the narrow jurisdiction given to it by Article 177(4). I say this because the court is confining itself to the meaning of the words in the very Article 177(2)(b), which deal with the election of president. I would close by repeating what Article 177(4) states. The Court of Appeal shall have exclusive jurisdiction to hear and determine any question as to the validity of an election of a president, insofar as that question depends upon the qualification of any person for election or the interpretation of the Constitution, and any decision of that court under this paragraph shall be final. And so, to my mind, this court has the jurisdiction, in light of Order 60 of 2020, to interpret those words to mean valid votes, if more valid votes are cast. I make the point that this court has no jurisdiction to determine whether the chief election officer's report was valid or not, because in the first place, the chief election officer was not present, was not represented, and all that this court can determine is whether it ought to place such an interpretation on Article 177(4). So it is important to make that point, that the court simply has the jurisdiction under 177(4), that interpretation jurisdiction, which relates back to Article 177(2)(b), to read the words as meaning valid votes cast, if more valid votes are cast. So in effect, my order is similar, is the same as the order of Mr. Justice Reynolds. And in closing, this court accepts that the jurisdiction in Article 177(4) of the Constitution is a narrow one and only concerns interpretation of constitutional provisions that deal with the qualification of the president and interpretation in relation to the specific matters falling within Article, well, in this case, Article 177, to be those specific words. Anything outside of this would leave this court to venture into an area in which it would have no jurisdiction. So I'm not satisfied that the court's jurisdiction is limited only to qualification of the president, but it enables a jurisdiction to interpret those words if more votes are cast as if more valid votes are cast within the meaning of Order 60 of 2020 for the purposes of the elections of the 2nd of March 2020. And I make no further orders but go back to the second application that was made by Esmond David, and that is that there be an interpretation of the words more votes are cast in Article 177(2)(b), and I grant that order, that there be such an interpretation, and that interpretation read more valid votes are cast, if more valid votes are cast in terms of the Order 60 of 2020. So all the other orders that have been sought are refused. The parties, each party will bear his or her own cost.
May it please the court.
Yes?
Your Honors, if I may, in light of the court's ruling in relation to only paragraph B, might I crave the court's indulgence for a stay of the order for at least 3 days?
Yes, that's
Your Honors.
We can do everybody.
Your Honors?
Sorry, I'm sorry. Does the applicant have anything to say in relation to the application for a stay?
Yes, Your Honor. We object to that. The court has rendered a decision in respect of which the Constitution of Guyana says that there is no appeal. The facts on the ground are that this matter has been engaging the population and people of Guyana for a considerable time. The facts on the ground are that this court has dealt with this matter with commendable dispatch. The matter having been filed on Friday, called on Saturday, a decision being rendered on Monday. Your Honor, I think that the ordinary process must now play itself out to finality. There is no useful purpose that a stay can serve, given the fact that the decision is final. And of course, the CCJ Act provides at section 4.3 that where a member state has legislation or a constitution which prohibits an appeal, that will be taken care of. That section will forbid an appeal. And in the circumstances of this case, I think that the prospects of, if one would apply the ordinary principles, the prospects of success.
Jeremy, we are prepared to grant the stay. We are prepared to grant the stay. You say for 3 days? Sorry, Mr. Khan. Mr. Khan, what was your application for 3 days?
My apologies. Yes, please, Your Honor. And I want to also join with Mr. Jeremy in commending the court for the dispatch with which it has dealt with the matter. It now gives us an opportunity to advise our clients as to any possible next steps. And we are certainly grateful for the court coming out on Saturday and rendering its decision 2 days after.
Yes, and we thank you as well, Council, all of you, for your cooperation in getting your submissions to us by email and generally being present and enabling the court to move with some dispatch, limiting your submissions to the times that were set by the court. We thought that Council did admirably in observing those guidelines. So we thank you as well for your cooperation, and we will try to tidy up our judgments and make them available to you or through the court, so that you will be informed when if you wish to engage the next steps. So thank you.
Much obliged.
Much obliged.